Good evening and welcome to our continuous revision. So tonight we would like to discuss civil litigation or civil justice system and the Ghana legal system and legal method. So you can supplement the discussion with reading chapter 6 of my book or reading appropriate chapter from Professor Kwanzaa's book as well, or any other useful material on the subject. So first and foremost, we need to understand the components of a civil justice system or the civil litigation system. And then we need to know like the various processes and the procedures. Now, when we have finished discussing this aspect, at another time, we will discuss alternative dispute resolution and to try and draw some paras and some contracts, particularly so for purposes of examination. Some, it's of course, is a very useful examination area to invite students, for example, to either make a case for alternative dispute resolution mechanism as a preferred method for resolving disputes over and above the civil justice or the civil litigation system. So to be able to do justice to a question like that, it is pertinent that we have a very thorough understanding of the intricacies of the civil litigation system, and aware of that, we would then be in a position to appreciate the shortcomings, the limitations, the demerits, or the constraints of the civil litigation system. And then we are in a position to appreciate the merits or the strengths of the various forms of alternative dispute resolution mechanism as arbitration, conciliation, mediation, negotiation, and so on and so forth. So as I indicated, the purpose of this session is to discuss civil litigation or civil justice system. So yeah, sorry for the break. So first and foremost, if you talk about the civil litigation system or civil justice system, or maybe civil procedure, we are referring to the various processes and mechanisms involved in bringing about a dispute for resolution in court through the traditional means of dispute resolution. If I say traditional means, what am I talking about? We know that we have criminal cases on one hand and we have civil cases on the other hand. So last time we attempted to draw a distinction between a crime and a civil wrong and all that, but that is not what we are doing tonight. What we are looking at is that where you have civil case, in other words, where you are complaining that someone has committed a civil wrong against you, such as committed a tort against you, defamation, nuisance, negligence, or the person has made a trespass onto your land, or somebody is owing you in the form of like a debt recovery, or where there's a breach of contracts, and so on and so forth. All these are civil claims. These are civil cases. So we want to revise, I would say revise, because as I said, the assumption is that all of us have learned these things already during our undergraduate days. So the purpose is just to help you to remind you of what you are supposed to know. And apologies for starting late, because this is what my schedule actually permitted me. So sorry about that. But the good thing is that we're able to actually get back and do some work. So let's get something done. Yeah, so if you have a civil case, if you have a civil wrong in any of the ways that I have actually explicated and exemplified, you need to find out what are the modes of bringing it to court. And at this stage, let me emphasize that we are not discussing alternative dispute resolution mechanisms. I mean, that is another topic for another day, so not for tonight. So tonight, we are quickly trying to revise civil litigation or civil justice system. So on that note, if you have a civil case, you need to find out whether you are going to have a writ of summons issued, or you are going to have a petition filed, or you are going to have what we call originating motion on notice. Yeah, so let me see if I can get the white. Yeah, so I don't know if my whiteboard can actually be seen. Okay, let me see. I think it's taking a bit of a while, but let me explain. So you need to, as I said, indicated, three main, of course, there are so many other ones, but the predominant ones are what you call the writ of summons, petition, originating motion on notice. So let us explain this basically before we take them other components. Yeah, sorry about the intermittent disruption of the internet connection. Yeah, so writ of summons is a formal document by which in the name of the Chief Justice, the sovereignty of the Republic of Ghana is actually invoked against another person, right? So the person who has a claim against you is called the plaintiff. And you, the person against whom he has a claim, is called like the defendant. So the writ of summons is the formal document by which we are invoking authority of the state, acting through the Chief Justice against the particular person. And that is what we call like the writ of summons. And that is the starting document in a civil litigation. So as I said, the party at whose instant the writ of summons is taken out is the plaintiff. Although if you look at the English textbook, you come across the word claimant, since Lord Wolf reforms in England, but we still use the old terminology, plaintiff, but the same as a claimant. And I've indicated that the writ of summons actually moves the authority of the state against the person that you have a claim against, and the person is actually ordered to enter appearance. In other words, to respond to the writ of summons by indicating that he or she is aware that you have invoked authority of the state against him or her. Yeah, we'll come and say more things about this pretty soon. At this stage, I'm just explaining the three modes. So now, no writ of summons. The second one, as I indicated, is the originating motion on notice. Originating motion on notice. It is another distinct way of commencing a civil action. Of course, it is not all type of civil cases or civil action which you commence using originating motion on notice, but for some of them you do. So what is it? To start with, Motion simply refers to application, right? One lawyer say motion, we are referring to application. Then when we say on notice, that is to say that an application you are bringing to court with notification to the opponent, so that the opponent is aware that you have brought application in court against him or her. And then we said originating, right? Originating, that is an application which is starting the case against the person. And that's what we said, originating motion or notice. So for example, if you take cases emanating from company law, right? Maybe somebody is disqualified as a director, or somebody is making a claim that there's oppression against him and all that. Then the law will say that an application may be brought. So you don't go and issue a writ, because the law itself has indicated that for that type of case, you bring an application. And because you are now starting the case, and you are starting it not by writ, you are starting it by application or motion. We call that originating motion on notice. So let us keep that in mind. And not only company law cases, of course. Yeah, so there are some enactments, some legislation, which will indicate that if you want to get a remedy, or you want to get interpretation or some other things, then you bring an application. And since you are starting the case by an application, you use what we call originating motion on notice. So let's keep that in mind. And then thirdly, of course, so okay, the originating motion on notice, the person who is starting it is called the applicant. And then the other person against whom the case is brought is called like the respondent. And quite apart from that, we also have what we call petitions, right? Petition in modern times is used purposely in relation to matrimonial causes or marital cases. So if someone wants a divorce, someone wants nullity, annulment of a marriage, and so on and so forth, you go to the court in the form of petition. Of course, we don't have the luxury of time. Otherwise, I'll have taken you through the historical reasons for having a petition, so-called, as it were. But that is to say, for example, we take like a matrimonial causes, for example, because of the Judeo-Christian background of the common law and all that, and the teachings on some of these matters, you are actually going to make a plea to the court that due to certain state of affects, the marriage has broken down beyond reconciliation, or that the marriage should be declared as a nullity, and then the court should give you a remedy and so on. So you do that in the form of like a petition. So this will suffice for explaining the three modes of commencing a civil action. So we've seen a writ of summons, we've seen originating motion or notice, and then we have seen petition. Now, let us look at the writ of summons in a little bit more detail. So the writ of summons basically will indicate the name of the court or the particular court in which the case is being commenced. It will indicate the parties, that is the plaintiff who is starting the case or who is making the claim against someone, and the other person against whom a claim is being made, called the defendant. And then again, the residential address of the parties will be indicated. And of course, in terms of the venue, like which particular town are you going to start the case? Usually, if it has to do with the case involve immovable property or landed property, then the rule is that you commence the case. You get a writ of summons to be issued out of the registry of the court at the place where the house is located or where the movable property is located. Or maybe if it's about maybe contracts, then you will bring the case at the place where the contract was supposed to have been performed and so on. So those are some of the ways in which you determine the venue, that is the place where the case should be commenced or where the writ of summons will be issued from. So let us keep that in mind. And again, in the writ of summons, so you will see the capacity in which the plaintiff is bringing the action, as whether the plaintiff is bringing the action in his own right or is bringing the action on behalf of another person. Maybe as, for example, holding power of attorney, right? So power of attorney is an instrument by which you empower someone to stand in your shoes. So if the plaintiff is, for example, bringing the case or the action on basis of power of attorney as a representative of someone, that will be indicated, or things like that. And another point to note is the issue of the writ. The writ is issued not by the party, so let's keep that in mind. Let's pay attention to the terminology. It's not the plaintiff who issued the writ. No, the writ will be issued at the instance of the plaintiff. The actual issuing is done by the registrar of the court. So let us keep that in mind. So the writ is issued by the registry or the registrar of the court. And the other point has to do with service. Where a writ has been issued, it must be brought to the attention of the defendant. That is the person against whom the writ has been issued. And how do you do that? You do that by having it served on the defendant. And there are two types of service, right? There are two ways in which a writ may be served. And as I've indicated, serving it simply means that you are bringing it to the attention of the person against whom the writ has been issued. So we have first, personal service, and two, substituted service. Personal service simply means that the bailiff of the court, out of which the writ has been issued, would have to take steps to get the writ, which is a document, served personally on the person, the defendant, is given to him or thrown at him, as it were, so that it will be considered as having been brought directly to his notice or to his attention. So let us keep that in mind. Then, quite apart from personal service, we also have what we call substituted service, right? Substituted service. Substituted service simply means that where an attempt has been made on 3 or more occasions to directly serve the defendant, as I've explained, by personal service, you have not succeeded. Either the defendant is evading service, trying to run away from the bailiff, or you probably do not know the exact location where you can reach the defendant and personally serve it on him or her. In that case, the law permits you to go back to the court in a form of ex parte application. Ex parte application means that you go to court alone without notifying the other party. Of course, at this stage, you've not been able to serve the other party, so there's no point in even you saying that you bring it on his notice. So the law permits you to go to court by ex parte application. and request the court to grant you permission so that you can have the writ served by means of substitution. And order for substituted service could be that the writ should be posted on the notice board of the court within the vicinity where the defendant resides. Or sometimes you are allowed to go and post it on the known resident or the particular place where it is expected that the defendant will be aware when it is posted there. Sometimes the court may also permit it for it to be published in a newspaper. So sometimes you are reading the Daily Graphic or other newspapers, and then you see court documents. All those are examples of substituted service. And in recent times, some courts even permit service to be done by WhatsApp, right? By WhatsApp message. And some may even permit Facebook. But you cannot effect service by any of these means on your own without first going to court to obtain permission to do that. So let us keep that in mind. Good. Now, just before we leave service, there's another thing that I should bring to your attention. What you call service outside the jurisdiction. What is that? It may well happen that you have sued someone who resides outside Ghana. So you've caused a writ of summons to be issued against that person. How do you get to serve on that person? A writ of summons cannot be served outside the Republic of Ghana because the writ of summons involves direct projection of the sovereignty of Ghana, which goes with the power of coercion and so on and so forth. Therefore, within the common law tradition, in accordance with our civil justice rules or civil procedure rules, where you have caused a writ of summons to be issued against a person residing outside Ghana, you would rather go to court and ask for leave. Leave by lawyer simply means permission. When we say they are going to call for a leave, it means they are going to get the permission of authority. You obtain a leave from the court so that you can have notice of the writ served outside the jurisdiction. For example, the person resides in the US, the person resides in Egypt or South Africa or wherever, and you want the writ which has been issued to be served on him. The writ itself cannot be served on the person. The court can give permission for a notice, right? For notification to be given to him or her that in the Republic of Ghana, this writ of service has been issued against you. And the reason for that, as I've explained, has to do with questions of what sovereignty. And you cannot project your sovereignty just into another person's jurisdiction just like that. So let us take note of that. Now, once service has been done, another component of the civil justice system is what they call entry of appearance. The person against whom the writ has been served, has been issued and actually served on him, must enter appearance. An appearance is supposed to be entered 8 days after being served with the writ of summons. When you are served with the writ of summons, you have 8 days within which to enter appearance. Now, what is appearance? Appearance is simply a document which you file indicating your address and then showing that you are aware that the plaintiff has sued you or the plaintiff has caused a writ of summons to be issued against you, and you are ready to react to it, you are ready to face him or her in court. That is the essence of entry of word appearance. An appearance is of two kinds. We have what we call unconditional appearance and what we call conditional appearance. Unconditional appearance simply means that you are saying that you are aware of the writ of summons or the suit, and you are ready to face your opponent in court at the appropriate time. Unconditional appearance, conditional, that's the qualified appearance, on the other hand, means that you are saying that you are aware that a writ of summons has been issued against you, but you think that there is something wrong with the writ of summons, or there is something wrong with the service of the writ of summons on you. And for that matter, you go to court subsequent to the filing of the conditional appearance to draw the court's attention to defects in the writ or defect in the service of the writ on you. So that is conditional appearance. So usually, after entering conditional appearance, you have maximum of 2 weeks or 14 days within which to go to court by means of application, motion, and draw the court's attention to whatever defects that you think are present in the writ, or whatever defect that you think are present in the service of the writ on you. So let us keep that in mind. On the other hand, where you have just entered unconditional appearance, then you have 14 days within which to file your statement of defense. 14 days within which to file your statement of defense. So statement of defense simply means that you are reacting to the various allegations which have been made by the plaintiff when he issued the writ, as well as in the accompanying statement of claim. We come and talk about pleadings very soon, but just let me take a step back with respect to the appearance. And that is to say that, what about where the defendant, having been served with the writ of summons, ignores it in the sense that he does not enter conditional appearance, he does not enter unconditional appearance. It's like he or she cannot be bothered. So where that is the case, what happens? Well, the law is that where you have been served with the writ of summons and 8 days have elapsed, there is what we call default of appearance. Because you are defaulted in entering appearance, the party who sued you, that is a plaintiff, is permitted by law to go to court and ask the court to enter judgment against you. Enter judgment against you. And especially so where the claim, the writ is seeking against you, that is the prayer, the relief, the remedy, which the plaintiff by his writ is seeking against you, is, let's say, a liquidated claim. Liquidated claim means that a first sum of what? Money, or amount of money which can be ascertained. Then he will ask the court to enter a final judgment against you for having defaulted in entering appearance. On the other hand, where the claim is, let's say, unliquidated claim and so on, then the courts will enter what we call interlocutory judgment. Interlocutory judgment in your favor against the other party for having defaulted in entering appearance. And subsequently, you have to go to court and do what we call assessment of what damages. In other words, prove to the court the quantum of compensation or the quantum of money that the court should allow you to recover. Good. Or where the claim is immovable property, for example, like land. You sue somebody for declaration of title to land, and the defendant having been served, 8 days have elapsed, and he or she does not enter appearance. So there's a default of appearance. You go to court, and you will not get a final judgment per se. You still have to go through the usual procedure and bring the basis of the claim for saying that the particular land, for example, belongs to you. Because don't forget that declaration in respect of land is considered a judgment in rem, not a judgment in personam. And since the judgment in rem, that is to say that it's a judgment against the whole world, so that if there's a declaration or pronouncement by a court of competent jurisdiction that this parcel of land, Black Acre, for example, Black Acre A or Black Acre B, that is a particular parcel of land A or B, belongs to you, then that is to say that it is no information to the whole world that you are the owner of that land. And that is why, even if there's a default of appearance by your opponent, the court will not just enter a judgment for you. You still need to bring some evidence for the court to base its declaration on it, as it were. But the good thing is that where default judgment has been entered, that the judgment has been entered against you for having defaulted in entering appearance, you can go to court later on and explain to the court why you defaulted in entering appearance. And when the court is convinced, the court can exercise its discretion to set aside the judgment which was previously entered against you in default of appearance. So let us keep that in mind. Good. So this will bring us to what we call like the pleadings. This will bring us to what we call the pleadings, which is a very important aspect of civil justice system. So when we say pleadings, what are they? When we say pleadings, what are they? Well, pleadings refers to formal allegations, right? Formal allegations made by parties to a dispute against each other. So the formal allegations which are made by parties to dispute against each other constitute what we call pleadings. And the purpose or the essence of pleadings essentially is to narrow the point of controversy between the parties. So that during the trial, the court is very much guided regarding the rare issue which the party dispute about. So pleadings is supposed to narrow the area of dispute. So you try to trade accusations, and then in the trading of the accusation, the formal allegation against each other, there may be some admissions, there may be denials here and there. So through that, what is really in dispute between you, the scope is narrowed, and that will guide the trial. So let us keep that in mind. What are the various types of pleadings? We have statement of claim, we have statement of defense. We have, of course, statement of defense is also accompanied by what we call like the counterclaim, and then we also have a reply. So I'm going to explain these aspects of pleadings. So first of all, what is a statement of claim? A statement of claim refers to formal allegations made by the plaintiff in support of the writ of summons issued against the defendant. In other words, A statement of claim is also a document by which the plaintiff gives a skeletal framework of the basis of his claim against the defendant, or the basis of his claim to entitlement of the release or the prayer in the writ of summons issued against the defendant. Don't forget that an essential aspect of the writ of summons is what we call the relief or the remedies, the prayers. What are you asking the court to grant in your favor against the defendant? They are the reliefs, they are the remedies, right? Either declaration of title or recovery of damages or recovery of debt and so on and so forth. Those are the reliefs. My question is, as a plaintiff, what makes you think that you're entitled to those reliefs? How did you become entitled to those reliefs by inviting the court to grant in your favor against the defendant? You do that by setting out your case in a pleading known as statement of claim. So the statement of claim, you explain how the underlying transaction between you and the defendant came about, and how the defendant came to be liable to you, or you think that you're entitled to something against the defendant. You use the statement of claim to explain that. So therefore, a statement of claim simply refers to a formal statement of allegations by the plaintiff in support of his writ of summons against the defendant. So let us keep that in mind. And it's spelled out in paragraph by paragraph. That is how it is. It's not just what do you call the unstructured complete prose. No, it is distinct statement, paragraph by paragraph. So each allegation should be given one paragraph and so on. Now, the statement of claim under the new dispensation, under the new civil procedure rules, both at the High Court and then in the High Court, in the Circuit Court, is supposed to accompany the writ of summons, so that when the writ of summons are being issued, it must be accompanied by the statement of claim. In the past, it was different. You get a writ of summons and subsequently do the statement of claim, but now the two go together. Writ of summons accompanied by statement of claim. And as I indicated to you, the author or the proponent of the statement of claim is a plaintiff. That is the person at whose instance the writ of summons was issued. And the intended addressee or the intended recipient of the statement of claim is the defendant. Now let me talk about the statement of defense and counterclaim. A statement of defense, on the other hand, is a formal document by which the defendant set up his case by way of defense to the allegations made by the plaintiff. So the statement of defense enables the defendant to react to the various claims, the various allegations being made by the plaintiff. So just like the statement of claim, the statement of defense is also structured paragraph by paragraph. So every distinct reaction is entitled to one paragraph. So you go to the plaintiff statement of claim, you take it paragraph by paragraph. If you think that what the plaintiff is saying is true, then you admit it. On the other hand, if you think that what the plaintiff is saying, for example, is not true, then you also have to point that out. So that is the statement of defense. Or sometimes you may say that what the plaintiff is saying is true, but you have an explanation, then you do that. Now, when you are done with the statement of defense, assuming you have a claim also against the plaintiff. In other words, yes, the plaintiff has sued you, but they're also saying that despite the fact that you have sued me, I have also got a claim against you. I also want to sue you. So as it were, or literally speaking, you have been sued. And in that suit, you're also going to sue the one who sued you. And that is why you call it the counterclaim. Of course, you've heard something counter. When you're learning law of counter, you hear about the counter offer. You know, the case of hide and wrench, but we're not talking about that. But here, we are talking about where A has sued B. So A is a plaintiff, B is a defendant. And the defendant, having set up his defense in the form of the statement of defense, also tells the A, that is the plaintiff, that I have also a claim against you. That way, the defendant will be doing what we call a counterclaim. A counterclaim. Now, where the defendant has put his, the defendant has been, served with the writ of summons. He entered appearance in 8 days. Then after 8 days, he's supposed to file the statement of defense. And if there's a counterclaim, the counterclaim will be embedded in the statement of defense. Now, when that is actually completed, it will have to be served on the plaintiff. And the plaintiff, once served, has also got 8 days within which to reply. The plaintiff is also entitled to reply to the statement of defense. And where there's a counterclaim, the plaintiff is entitled to also set up his defense to the defendant's counterclaim. So here, you notice that in respect of the counterclaim by the defendant, the plaintiff, as it were, will also become, if you like, a defendant in a sense, because he too will have to also react in the same way that the defendant reacted to the plaintiff's initial statement of claim. Now, reply. What is reply? As I said, reply is actually filed by the plaintiff in reaction to the statement of defense. And this is usually done in 8 days. So if the plaintiff, for example, disagree with the particular defense, which the defendant is setting up, he will join issues on it, and then he will also state any explanations which is there, and so on and so forth. So these are what we call pleadings, right? And as I said, the purpose of pleadings is essentially to narrow the controversy or the dispute, the area of dispute between the parties. And during the trial, evidence which will be adduced before the court will have to follow the path of the pleadings, will have to follow the framework of the pleadings. In other words, the pleadings are allegations, right? And as you know from the adversarial litigation system, A incubit, probatio, oratio, and so on. He who asserts must what? Must prove. So if you are making assertion by way of allegation, then you have a burden of producing evidence in respect of that allegation that you are making before, in the mind of the tribunal of facts, it will become persuaded that you have met, let's say, the burden of proof on you, or the burden of producing the evidence, as it were. So the pleadings are not just for fun. They are meant to control adduction of evidence. And that is why when you go to court and the trial is unfolding, sometimes you hear a lawyer just jumping on his feet when a witness is bringing a certain evidence, and then he say that objection. And sometimes the basis of the objection may be that the particular evidence which is being elicited or which is going to be tendered is, for example, not borne out by the pleadings which have actually been put by the parties and so on. So let us keep that in mind. Now, just before I continue, I have noticed that one Ernest has asked a question. What about rejoinder and then Sarah, rebuttal, and so on? Okay. Now, in the past, those things were quite common, but under the current dispensation, the usual pleadings are statement of claim, statement of defense, and counterclaim, if any, and a reply. The rule says that where reply has been filed, no one can file any pleadings unless you go to court. So it is theoretically possible for, if you like, rejoinder and Sarah rebuttal and so on to all be filed. But it is not something you can file as of right. As of right in the sense that you cannot just file it in reaction to what the opponent has brought without going to court to get leave first. Statement of claim is as of right. Statement of defense is as of right. Contempt claim is as of right. Reply is as of right. But beyond reply, if you think that you still want further pleadings, you must go to court and convince the court. Why the court should allow you, for example, to either file something subsequent to the reply and so on. So that, let's say that for you, the defendant, you still want to react to the reply which the plaintiff has brought to your statement of defense. So you need to go to court and get permission to do that. Or let's suppose that as a defendant, you made the statement of claim a counterclaim, and the plaintiff has, for example, set up his defense to a counterclaim when you file the reply, and you think that you want to also react to the defense to your counterclaim. You cannot do that on your own. You must go to court and get the leave to do that. So let us keep that in mind. The other point we also like to talk about is what you call the summary judgment. Summary judgment simply means that a plaintiff who has sued the defendant can go to court and ask the court to grant him or her a judgment without going through the laborious path of full trial. Now that will be permissible where the plaintiff is able to demonstrate that having regard to the case as per the pleadings, there's no way that the defendant will be able to set up an evidence which will prevent the court from granting a judgment in the plaintiff's favor. And for that matter, the court should go ahead and enter plaintiff for the judgment. Enter a judgment for the plaintiff, as it were. So that is permissible. So where that is done, then the court is excused from the burden of going through a full-scale trial. I've seen that someone's hand is up. Let me see what the person has to say. Let me see whose hand is up. Okay, Ison. Yeah, Ison. Yeah, go ahead. Oh, Ison, go ahead.
Hello, sir.
Yeah.
Good evening, sir. Sir, thank you. I wanted a clarity. I think I lost you at a point. I wanted a clarity when you initially submitted on statement of defense. Is it that the state one may choose the defense may choose to counterclaim without necessarily responding to the pleadings of the plaintiff, or he may decide to do both concurrently in the same document.
Oh, right.
If that
okay. Yeah, go ahead.
If that is so, with the counter claim as well, and then the statement of defense, is it necessary to have both of them in the same document, or you can file them separately? So you file the statement of defense and then you file the counterclaim differently.
Okay, all right. Thank you. Yeah, so the statement of the defense and the statement and the counterclaim is in one document. So what happens is that the statement of the defense is above, and then immediately towards the bottom of the statement of the defense, you follow it up with the counterclaim. So that is one. And two, the other question you asked as whether you can choose not to file a defense but do counterclaim. Of course, that is a risk which you are running. If you think that you have no defense with the statement of claim, that is fine. Then you make your counterclaim. And then when you make your counterclaim, you need to explain the basis of the counterclaim. In other words, why you think that you are entitled to make that claim against the plaintiff. Then you need to do that. Yeah, so that is fine. Another point to touch on before we go to trial, judgment, and enforcement of judgment, and then we are done, is that we have what they call applications or motions. If you talk about applications or motions, from the start of the civil case, right, up to judgment, and even from judgment up to when the judgment is fully implemented, it may be necessary from time to time to go to court and ask the court to grant certain orders, as part of the case. Now, you go to court by way of application. So when you make the application, you file a motion, right? So sometimes once a case has started and all that, between when the case is completed and all that, there may be so many applications or so many motions which may be made. Either you are going to the court for direction as to how to do certain things in the case, or in some cases, you even need injunction. As we saw the other day when we were discussing remedies, what we call the interim injunction and interlocutory injunction. All these are motions which you bring to court, or you need some other things in relation to the case. You go to the court by way of motions. And the general rule is that every motion should be on notice in satisfaction of the natural justice principle, okay? So that the court will observe the odi oteram partem. That is, hear both sides of the matter before you make a determination. And that is why every motion, as a general rule, should be on notice with the other party. Of course, we have exception, as we have seen that where they are going for, let's say, substituted service. In that case, by nature of the prayer you're looking for, it does not admit of you going on notice, because you're going for the substituted service simply because you don't get the party to serve. So therefore, you go alone. And so that one, ex parte is what is permitted. Otherwise, in most cases, you need to go on notice. And the other one is also where you're going for interim injunction. That one, you go on, you can go ex parte. Interim injunction is usually for a limited time. That is for about maximum of 10 days, especially having regard to the exigencies and the urgency of whatever matter that you have at hand. You can go to the court and ask the court to grant injunction to preserve the status quo. And because the court has not had the opportunity to hear both sides, the court may be persuaded and said, okay, I'm going to grant it, but it will be for a very short period. Make sure that you repeat this application on notice to your opponent so that your opponent will also come and react to it before the court to make up its mind as to whether the injunction, for example, should remain in force pending final determination of the suit and all that. So let us keep that in mind as well. Okay, so this will bring us to another step of the civil procedure. Of course, you are not doing civil procedure as a full-blown course, which you do in the law school, but this is just within Ghana legal system. And don't forget that Ghana legal system is a first-year course. So the way that we'll pitch the discussion will be what is expected of an undergraduate studying civil procedure within Ghana legal system. Now, if we're in the law school and we're learning this, you'll be a bit more detailed and a bit more advanced than how we are going about it here. Good. So we also have what we call the application for direction. That is after close of pleadings. Now, when the reply has been served, pleadings are said to have been closed. And then you come to what we call application for direction stage, right? Now, we have a rule which says that when you get to the application for the directing stage, the court must refer the case to a court-connected mediation procedure. In other words, the parties are mandated to explore the possibility of resolving their dispute by, ADL, typically mediation, without having to go through the full-scale trial. Now, where that is successful, the agreement reached by the parties will be brought back to the court, and then the court can adopt it as what we call consent judgments. And that will mean that finality has been brought to the case, and what the party have agreed upon will be given judicial imprimatur or approval in the form of consent judgments. On the other hand, where there has been a failure to reach a deal when the court directed the mediation, then issues will have to be actually set down. The tribal issues will have to be set down. In other words, having regard to the pleadings which the parties have made, what are the questions, the issues which arise for trial? So those things will be formulated, and then the parties will be directed to file their witness statements. So witness statements refers to a written account of the testimony which the parties and the witnesses seek to tender during the trial of the case. So after the witness statements and the accompanying exhibits have all been filed, the court will go through what we call CMC, that is Case Management Conference. And the purpose of the Case Management Conference is to make sure that everyone has filed witness statements. If there are exhibits, the exhibits are going to be labeled or marked by the court so that during the trial, there will not be a delay. The trial can proceed expeditiously. Now, after the case management conference, the court will actually fix a date for trial to start. So now let's talk about trial. So during trial, usually the plaintiff will be invited to open his case, and he will go through either entering the box himself or herself, or letting his witnesses do that. And the witness statement, which was actually crafted, will have to be tendered as evidence in chief by that particular witness. And after it has been concluded, the court will invite the opponent to challenge the witness in the box, whose witness statements has been adopted as his evidence in chief. And this challenge is what we call cross-examination. So the opponent will cross-examine him, meaning that challenge him on the evidence, either to show that what he has said is not true, or is not credible, that it cannot be believed, or that he himself is not credible, is not someone that the court should believe as being capable of telling the truth, and so on and so forth. All witnesses will go through that. And when the plaintiff has finished calling all his witnesses, the defendant will also go through that and open his defense. And the plaintiff will also have to cross-examine the defendant or the defendant and his witnesses, as it were, until all the witnesses have been actually exhausted. Then there's something you also called subpoena. Subpoena refers to summons to a witness, right? Where a particular witness is needed, and either you think that if you call the witness will not come, or you want the court to call that witness, you get the court to issue subpoena tecum or subpoena a testificandum on the particular witness to come and testify or tender document, as the case may be. So let us keep that in mind. Now, after all the witnesses and everything, the court will invite the parties to address the court. So you go to what we call the address stage. The court will invite the parties to address the court. Addressing the court means that the court will ask the parties to comment on the evidence which has been adduced before the court so far in relation to the applicable law, right? So this is where the hierarchy that we know will come in. You go back to the issues which were set down for trial. You look at the relevant law and look at the evidence which actually came before the court. If you do the evaluation, the analysis, you need to show the court that the evidence before the court, for example, supports the case of your side, of your client, either the plaintiff or the defendant, as the case may be. So let us keep that in mind. So after the address by the parties, then we go to the judgment. The court will now deliver the judgment, in which case the court will determine whether the plaintiff was able to meet his burden of proof, and for that matter, has satisfied the case that is entitled to the reliefs which he has stated on the writ of summons, or vice versa. So now we have judgment. Judgment has been entered. You need to now enforce the judgment. You need to implement the judgment. There are various ways of actually enforcing the judgment. Enforcing the judgment simply means that you are implementing the judgment. You are letting the judgment work as it were. And usually, the mode of execution that you go for will probably depend upon the nature of the judgment, the nature of the prayer, which the court said you are entitled to. So we have what you call the garnishee order. You have a writ of fieri. We have the commital order, also known as like the contempt of courts. We have the writ of possession, and so on and so forth. So writ of, let's start from, let's say, garnishee proceedings. So garnishee proceedings is where you have a judgment against someone, and that person has got money or some other things out of which money flows in the hands of another party. Now you get the court to order the person who is in custody of money belonging to the judgment debtor to come to court and show cause, that is, explain to the court why he should not be made to, for example, hand over the money in his custody to you as a judgment creditor in satisfaction of the judgment that you obtain against the defendant, whose money that person is in custody of. So that is the garnishee proceeding. So usually, the first stage, what you call you let the person come and show cause, what you call like the garnishee order nisi. So you just go as party, you let the court order the particular party who has the money in his possession to come. And then when he or she come, you come and make the necessary disclosures to the court. And then the court will then decide whether the person should be made to, for example, hand over the money to the judgment creditor in satisfaction of the judgment debt. So that is a garnishee proceeding. Then we also have what we call the writ of fieri, by which the registrar, working on the sheriff, and also sometimes the appointed auctioneer, would forcibly seize assets belonging to the judgment debtor and have those assets sold so that the money will be used to satisfy the judgment debt. So that is the rate of fieri. And we also have like the rate of possession, which is used actually in relation to enforcement of judgments pertaining to land, where the registrar, assisted by the police and all that, will get the person in wrongful possession removed from the movable property, so that the judgment, the person in whose favor the judgment is pronounced, be put in possession of that property. So that is the rate of possession. And of course, implementing that always involves the use of rate of force. So you get like the armed police and other things there to assist that to happen and so on. Good. Then we also have what we call the commital order or contempt of court, where there is an order of the court, and someone, for example, disobeys that order, or someone does anything to undermine the authority and majesty of the court, then the commital proceedings may be done, and then the court may actually convict the person of a contempt of court and either fine the person or either sentence the person to imprisonment as it were. Okay, so this will mark the end of our discussion for the night, and I'll take comments and questions so that we continue another time. Okay, I haven't seen any hands up, so, and I haven't seen any question in the chat. So I presume that there is no question. Somebody say how our judgment, but that is not complete. Okay, then have a good night.